Good afternoon. Thanks for joining us today for the 16th Annual Chancellor's Leadership Forum on Diversity and Outreach. Before we begin, please note that we are dedicating time during today's session to answer your questions. We know that the topics we cover are very important to you, and we appreciate your engagement. Please be mindful of our UCSF pride values and be respectful in your comments in the Q&A. We will try to answer as many questions as we can during the time allotted. Thank you. And now it's my pleasure to introduce Dr. Renee Navarro, Vice Chancellor of Diversity and Outreach.
Welcome to the 16th Annual Chancellor's Leadership Forum. Today, we're looking forward to the Chancellor's conversation. I'll start by sharing a brief update on our actions that are seeking to cultivate a culture of belonging, followed by our main event, the Chancellor's timely discussion of freedom of expression. Next slide. First, I'd like to start with the UCSF land acknowledgement. We would like to acknowledge the Ramaytush Ohlone people, who are the traditional custodians of this land. We pay our respects to the Ramaytush Ohlone elders, past, present, and future, who called this place, the land that UCSF sits upon, their home. We are proud to continue their tradition of coming together and growing as a community. We thank the Ramaytush Ohlone community for their stewardship and support, and we look forward to strengthening our ties as we continue our relationship of mutual respect and understanding. The UC system has implemented a new system-wide policy on anti-discrimination. Effective February the 20th, this new policy clarifies and strengthens the commitment to equal opportunity and freedom from harassment or discrimination as defined by state and federal law. In addition, President Drake has launched a new system-wide Office of Civil Rights. This office will oversee the new policy as well as Title IX policy and ADA, Adults with Disabilities policy, and key components of this work, and they will proactively work with our campus communities on areas of prevention. When we talk about the impact at UCSF and looking at our culture of belonging, next slide, we can see that UCSF continues to make progress in a number of initiatives. Consistent with our anti-racism pillar of safety and the President's task force, we launched our Police Accountability Board in October of 2023. This body sees civilian complaints that are investigated and overseen by this campus committee. You can find more information about this at our website. And we're pleased to note that no complaints were lodged for all of 2023. Additional climate and belonging efforts are being led by our inaugural Assistant Vice Chancellor of Climate and Belonging, Dr. Eddie Ruiz. He was appointed in August of 2023, and he's advancing support through our resource centers and our care advocates. The Climate Survey Planning Committee is co-led by Dr. Ruiz and Dr. Elizabeth Ozer, and they're moving forward with our UCSF Climate Survey 2025. Designed to measure the working and learning climate across the entire community with a focus on diversity, equity, and inclusion, the survey will follow up to the 21-22 survey and will be administered in January of 2025. Gender recognition and lived name policy, this UCSF policy, is on track to be fully implemented by July of 2024. We will be advancing an educational campaign to support our efforts to affirm gender identity and the utilization of lived names. We want to continue to support our community affected by the conflict in the Middle East. Several events for healing and support of our Jewish, Israeli, Palestinian, Muslim, and allied communities have been hosted since October of 2023. A compilation of information and resources is available on the ODO website. We're working with impacted communities to combat anti-Semitism, anti-Muslim sentiments, as well as Islamophobia. Our campus advocacy resources and education, the CARE program, issued its first impact report. This confidential campus resource is for individuals who have faced harassment or discrimination and have been impacted by that. They're there to provide you with resources in a confidential manner. They've reached over 554 staff and faculty and over 1,000 students through education, training, healing support, as well as providing individual supports to members of our UCSF community, both campus and health system. In the next slide, we see another initiative, which is our Institute for Diversity, Equity, and Anti-Racism Leadership. The Ideal Academy was formed with the goal of providing professional development for DEI leaders through increasing the leadership competencies in DEI and in anti-racism, advancing education and training on the history and impact of racism in health sciences, as well as advancing strategic implementation of equity initiatives across our institution. They are building and aligning cohorts, and we're proud that we are in our second cohort with over 50 participants to date. In our next slide, I wanted to highlight the fact that UCSF has a long journey towards greater equity and inclusion. We're delighted to have received the NIH's Institutional Excellence in DEIA in Biomedical and Behavioral Research Prize competition. We were one of only 10 institutions nationwide to be recognized. In addition, as we celebrate women's history, we want to honor the over 50 years anniversary of the Campus Committee on the Status of Women and the progress on gender equity that we have made. The Office of Diversity and Outreach is also looking towards celebrating a milestone of our 15 years at UCSF. And just a brief glimpse at some of the upcoming events for the rest of the year, you will see that we will open in March the Chancellor's Awards for Diversities. The nominations will be coming. In April, we'll celebrate Arab American Heritage Month, followed by, in May, Asian American and Pacific Islander Heritage Month and Jewish Heritage Month. June rounds out our academic year with our Pride Month celebrations and staff resource days for June 3rd through 7th. And now, the main event. Please join me in welcoming our Chancellor, Dr. Sam Hawgood. Dr. Hawgood was appointed the 10th Chancellor of UCSF in 2014 and also holds the title of Arthur and Tony Rimby Rock Distinguished Professor. With that, Dr. Hawgood.
Thank you, Vice Chancellor Navarro, for your updates. I appreciate all that you and your Office of Diversity and Outreach do to nurture a culture of equity and belonging across our campus and our health system. So now I will turn to a discussion of important issues that are currently front of mind for many of us here at UCSF and at other institutions across the country. That is free speech and academic freedom. What do those terms mean? We have invited University of California, Irvine Chancellor Howard Gillman, a nationally recognized constitutional law scholar, to share his knowledge of these issues in conversation with me and with us. Chancellor Gillman became the 6th Chancellor of UC Irvine in September 2014, the same year I became Chancellor here. Under his leadership, UCI has consistently ranked in the top 10 of all public universities in the nation, and it has expanded its capacity to improve lives in its region and around the world. Chancellor Gillman grew up in North Hollywood and was a first-generation college student, earning bachelor's, master's, and doctoral degrees in political science at UCLA. He is an award-winning scholar and teacher of the American Constitution and the Supreme Court. He serves as co-chair of the National Advisory Board for the UC National Center for Free Speech and Civic Engagement. His most recent books are Free Speech on Campus, the subject of today's conversation, and a second book, The Religion Clauses, The Case for Separating Church and State. Both have been co-authored with Erwin Chemerinsky. So thanks for joining us, Chancellor Gillman.
Thanks so much, Sam. It's truly an honor to be able to speak with you and to speak with your community. Thanks for the invitation.
No, it's wonderful. And I'll call you Howard and you call me Sam. It would feel just too weird calling each other Chancellor, seeing we've been Chancellors together now for 10 years.
Agreed.
So let me start, Howard, by just asking, given your background and career progression, what got you interested in constitutional law to begin with? And then what your particular focus on the First Amendment?
Well, I grew up in the San Fernando Valley, only child in the 60s and 70s. This was a time when there were extremely important developments in terms of civil rights advocacy and anti-war advocacy, and the Supreme Court in American constitutional law was really transforming into providing a broader set of protections for people who were challenging conventional wisdom, who were advocating for progressive causes. The court was extending innovative protections to countercultural art and expression. George Carlin was allowed to say what he was going to say without getting thrown in jail. And so it was a very important time for the role that free expression was playing in unleashing a lot of progressive dynamism that historically had been restricted by the government. And then, when I was about 14 or 15, the Watergate hearings happened. This was when there's only 3 television stations and I was an only child. So I had a chance to look at that drama. It got me very interested in judicial politics and constitutional law. And so I knew when I started teaching it, when I started being a student at UCLA, that I really wanted to learn about constitutional law and politics. And then really since 2015, 16, since this kind of most recent wave of argumentation on campuses about the proper scope of free speech and academic freedom, I just decided it was essential to learn as much about that as possible. Irwin and I started teaching courses together. I've been teaching courses on this for 9 years. We're writing books together. We're working with the UC National Center. And I really think it's been important for me to take a bit of my background and try to use it to engage these very important contemporary debates.
Great. Well, thank you. And we're lucky to have you in the system. Now, obviously, we as a country and here at UCSF value the right to freedom of speech and to express ourselves as a fundamental right. But could you share how freedom of speech is defined, and especially what the obligation of the University of California as a public government institution is to protect those freedoms, as you will define them for us?
Sure. And so let me say, by the way, if all of us were starting to take a law school course on the First Amendment to really understand the obligations of free speech, the casebook we would get would be about 1,200 pages long. So I am going to try to simplify it because it doesn't help it for me to say it's a very complicated issue. But everyone's going to understand that there are nuances associated with all of this. If you wanted to boil those 1,200 pages down, the basic idea of free speech protection under the First Amendment in the United States is the following: that the government cannot censor or punish a person merely for the expression of an idea or a viewpoint, even if people think that idea or viewpoint is dangerous or hateful. And if we break that down, what that means is it is a restriction on the government. So the First Amendment applies to government action, not necessarily to private action. So public colleges and universities, Sam, you and I are the government for purposes of the First Amendment. That prohibits us in most circumstances for censoring or punishing someone merely for the expression of an idea. Now, let me jump in quickly and say, there's a lot of things you can do with speech other than express viewpoints, right? You could rob banks. You could libel someone. You can genuinely threaten someone. You can harass people. So there are categories of speech activity that are not protected. And there's technical definitions in the law about these unprotected categories of speech. But what they all have in common is that you need something other than the mere expression of an idea in order for it to be protected. Now, we casually say all the time, that idea, that makes me feel threatened, or I find that idea harassment. And so it makes sense in a colloquial way that sometimes we would use those words. But from a First Amendment point of view, the mere expression of an idea in and of itself cannot be considered a threat or harassment or an incitement, for example, to lawlessness and violence. And unfortunately, this means that the government has to be viewpoint neutral with respect to all opinion, which means that there is no category of unprotected speech in the United States known as hate speech. It doesn't mean that we can't characterize speech as hate speech. It doesn't mean we can't denounce speech as being hateful. But under American constitutional law, there is no category of something called hate speech that you and I as the government can censor or punish merely because it was expressed. And Sam, the last thing I'll say is, just because you have a right to say something doesn't mean that you could say it anywhere at any time, any way that you want. And so one thing we have to remember is that even if you're expressing constitutionally protected ideas, government is allowed to impose what are known as time, place, and manner restrictions. So you might have a very important viewpoint you want to convey, but you don't have a right to convey it in the middle of a freeway during rush hour. You may choose to do that, but you don't have a constitutional right to do that. You don't have a right to barge into a judge's chambers during a trial and make a speech. You don't have a right to get a sound truck and go into a neighborhood, a residential neighborhood in the middle of the night to give your speech. So in addition to protecting people's right to express themselves, there are limits that are appropriate on when and where and how you can express it, as long as those limits are rational, well justified, and are viewpoint neutral. That is to say, you apply them regardless of the viewpoint, then those restrictions are legitimate as well.
Great, thank you, Howard. And we'll get into that that very nuanced issue of time and place a little bit later in our discussion.
Okay.
Now there was a great recitation of free speech, but as an academic institution, like all universities, we also hold very close the importance of academic freedom, the safety for our faculty and students, et cetera, to engage in intellectual discourse without fear of censorship or retaliation. So can you just talk about the similarities and the differences, if any, between what is meant by academic freedom and what is meant by free speech, and where do they intersect and where are they different?
It's a very important question for an academic community, because while free speech and academic freedom are both designed to extend certain protections for expressive activity that might otherwise be objected to, they are very, very different concepts. So what's different about academic freedom versus free speech? So the first thing that's different is that academic freedom attaches to faculty when they are engaged in exercising their professions as scholars and teachers, which is to say, academic freedom is premised on the assumption that a scholarly faculty with well-earned expertise should have discretion in best deciding, for example, what kind of inquiry to engage in, should have discretion in deciding how best to teach high-level concepts in university environments, and should have freedom to express and convey that expertise to broader audiences. So academic freedom, includes rights of teaching and pedagogy. It includes rights and privileges of scholarly inquiry and research and creative activity, and it includes the ability to convey those ideas more broadly, for example, to extramural or outside the university audiences. But it only applies to faculty on the assumption that faculty have this expertise, in a way that's very similar, I think, to the kind of deference sometimes that's given to physicians because of their expertise, to use their best judgment to decide how best to care for their patients. The assumption is these are professionals. They should have a certain degree of autonomy in making those decisions. But there's two other very important differences between free speech and academic freedom, other than academic freedom applies to faculty while they're working and free speech applies to everyone. The first is that it is presumed that academic freedom is attached to responsibilities to act in ways that reflect the highest standards of the profession and the ethical requirements of that profession. And so when you are engaged in academic freedom, it is your expertise as a scholar that is being respected, but that means that you must act in a way that is consistent with the highest standards of your discipline or profession. That means that, for example, that when you're teaching, that you should be exercising that in a way which reflects your competency as an expert in that field and making judgments about the best way to convey that information. And it means that you have to act in a way that would be viewed by other experts as consistent with your professional responsibilities. Now, just as physicians are, within a knowledge community where other physicians engage in a kind of peer review occasionally of how well or poorly people are doing, within academic freedom, the role and the boundaries of academic freedom are not decided by individual faculty saying, I just want to do this. They are bounded, including within University of California policy, by the faculty as a whole engaged in its ordinary peer review process, right? So if you're in a classroom, you are obligated to act as a professional in that classroom. And if you act in ways that are improper, your colleagues do have a right to say that's outside of what a legitimate boundary is for a professional doing their job within the University of California. Same thing with scholarship, right? You don't get to publish whatever you want to publish because you think it's a good idea. It's always going to be bounded by peer review. And so one way of thinking about some of the differences between academic freedom and free speech is that free speech allows anyone who's not a professional outside of the teaching profession to say what they want. It doesn't have to be competent. It doesn't have to be true. If you want to go to City Hall and say the moon is made of green cheese, the mayor can't arrest you for saying something that they think is wrong. But if you're trying to get tenure in an astronomy department and you're trying to teach the moon is made of green cheese or publish a paper saying the moon is made of green cheese, your colleagues could question that. And if they think that that opinion is not consistent with the highest standards of the profession, then you could be judged, you could be evaluated, you could be sanctioned. And what that means finally, Sam, is that in an academic setting, faculty members have both academic freedom rights and free speech rights, depending on where they are. So the classroom is a professional space governed by academic freedom norms. The classroom is not a general free speech area where you can say or do whatever you feel. But you could leave the classroom, and if there's a protest on campus that you want to participate in, then you're free to engage in general free speech when you're not in the midst of actually exercising your professional responsibilities.
Yeah, that's great. I think you clearly said it, but just to clarify, you said academic freedom rights are restricted to faculty and don't apply to students. What's the thinking behind that concept?
So it's very interesting. If you look at the University of California policies on academic freedom, it's in the Academic Personnel Manual. Anyone could look it up, APM 010. It discusses the importance of academic freedom for faculty, the rights that a scholarly faculty with great expertise should have. And because the concept of academic freedom attaches to people as a result of their scholarly expertise, the assumption is that students don't have that status, right? They're still learning to master a discipline. And so within that context, a student doesn't have the same privileges that faculty members do. That means in a classroom, for example, a faculty member gets to decide what the legitimate boundaries of discussion and debate are, what legitimate arguments, strong and weak arguments are. And the fact that a student may have an idiosyncratic point of view that their analysis of, I don't know, what Moby Dick means, deserves as much credit as anybody else's. Unfortunately, no, it has to be the experts in literature and literary studies that make that determination. On the other hand, the University of California makes it very clear that even if students don't have academic freedom, they must be treated in a way that respects their independence of mind, that faculty have an obligation to allow them to ask reasonable questions. The point there is to develop in them, in fact, an independence of mind, and that students are deserving of being treated in a way where a highly qualified person trying to help them to understand will create an environment within which they can understand high-level material.
Great, thank you. Let's turn to more of a workplace issue. So at UCSF, just like UCI, our work spans learning, classrooms, research labs, but an integral part of our work is also providing patient care.
Yeah.
Clinical environments are quite distinct from the academic environments. Patients who are vulnerable by virtue of illness appear and often have no choice in their care team. We've heard, and I suspect you might have as well, from patients over the last few months who worry that they cannot trust care from professionals whose strongly held views are evident either in what they wear or what they say. So how might freedom of speech differ in a healthcare environment from the general academic campus educational environment?
You know, it's a very important question. And normally when these debates happen, they're on general campuses that are focusing on free speech, academic freedom, and there's not a lot of discussion of the clinical environment. But I do think the clinical environment is an important additional space, which is very analogous to the space of academic freedom. So I mentioned that when you are engaged in your profession, you must act in a way that is consistent with the highest standards of your profession. If you're teaching American literature, you have to do it in a way that's appropriate. You can't use your classroom just to go on diatribes about the presidential election season, right? And so you have to act as a professional. Those same expectations attach, I mean, perhaps even more so in a clinical setting, right? When you are in a workplace environment as a highly qualified professional, you must conform to the standards of that profession. Now, one thing that may be an interesting difference is that within a general campus environment, let's say an arts and sciences environment, whether or not someone is operating in a way that is consistent with the expectations of that profession are normally ascribed to the faculty as a body, as part of a normal peer review process. In a clinical setting, a lot of that assessment will take place with respect to physician behavior, for example, with the medical staff. Right? There is an expectation, if you are in a clinical environment as a physician, that you have to act in a way that's consistent with your professional obligations and responsibilities, right? That you have a duty of care, you have a duty of creating an environment that's consistent with people having confidence in your ability to provide that care. And while you have some discretion, it's not a blank check. And, you know, the medical staff could evaluate people's behavior based on whether, I don't know, certain judgments are consistent with best practices and, you know, how best to analyze, you know, to do a root cause analysis if something didn't quite go right and to create, you know, new norms and policies going forward. But there's also a sense to which if a physician faculty member in a clinical setting is acting in a way through expressive conduct that also seems inconsistent with professional standards, medical staff, I would assume in normal circumstances, would have the authority to evaluate whether the way that people are interacting, the kind of behavior they're engaging in a clinical setting is consistent with those professional standards. So I think it's an analogous situation, right? With the difference being that on the general campus side in, let's say, classroom settings or research lab settings, the body that is doing the peer review tends to be just a faculty body. And in a clinical setting, the analogous body that is doing that peer review, both protecting your rights and privileges, but also establishing those boundary conditions, would probably be a body like the medical staff.
Great. Thank you, Howard. Shifting gears just a little bit, you know, as we're aware, in the last 20 years or so, various new means of communication have arisen. Social media, online platforms, they can be exponentially amplify news, opinions, viewpoints, and this can be, in many cases, of great benefit when sharing a new discovery or when innovators are able to connect across geographic barriers. Other groups can form and communicate like never before.
Yeah.
And many of our community members are active on social media on their own personal accounts as leaders in their fields with large online followings. So what does social media bring to our conversation? What differences are there in how a person can exercise freedom of speech and academic freedom on social media versus other forums such as in-person speaking or expressing your views in an op-ed in the newspaper? Are there distinctions based on the means of communication?
So on the one hand, the means of communication don't matter so much with respect to the basic principles, but it certainly complicates a lot of the judgments and assessments. And let me give you an example. So if you can express a constitutionally protected viewpoint in places where you're allowed to do so, in person, at a park, you know, on the grounds of a campus where you're allowed to express yourself. And you can also express yourself on social media. If you're merely expressing an opinion the medium by which you express that opinion tends not to be so important. You can do it in person. You could write an op-ed. You can do it online. This also means, Sam, by the way, that when it comes to unprotected speech, you can engage in unprotected speech and get in trouble, right? Get sanctioned or punished by engaging in unprotected speech in an online format as much as you can in person. You could certainly in a workplace harass someone in person, right? You could harass someone walking around a campus in person. You can threaten someone in person, but you could also harass or threaten someone or engage in other unprotected speech online. And so to that extent, if you are expressing yourself in any media in a way that is constitutionally protected, then generally speaking, all of the requirements of the First Amendment attach. But if you're acting in ways that could be punishable in an in-person setting, then they can also be punishable elsewhere. But, Sam, as we know, it used to be that, you did your job, you went home, and if you had a bundle of opinions that a lot of people thought were disagreeable, hardly anyone would know about them except for your neighbors and your, family members. Now it's very easy to generate a lot of controversy because your access to millions of people who otherwise would have no idea what you were saying about anything is immediate. And on the one hand, there's this incredibly liberating quality, but on the other hand, it does mean that there's much more of an actual impact of you expressing yourself in controversial ways than has been the case ever before in history. And I'll say, Sam, as a general rule, and these are general rules that get complicated. Remember, the case book is 1,200 pages long on this. As a general rule, if you have a private social media account and you're expressing a constitutionally protected viewpoint under a lot of circumstances, but not necessarily all circumstances, that viewpoint has to be protected by the government, right? You might engage in expression that is not protected, and that's a different situation. But if you're expressing yourself in those fora, it would be protected. So a faculty member in a classroom governed by professional requirements and responsibilities, a faculty member engaging in a protest can do that as long as they're not breaking the law. Faculty member in their private social media, generally speaking, can express themselves. And the same, not just with faculty members, the same with students, right? And the same with staff. There are some circumstances, though, where the expression of opinion in other settings, including social media settings, does create extreme difficulty for whether or not a person is capable, in light of the controversy associated with that expression, of actually engaging in their profession, right? And that's when it becomes very complicated, and it's a very fact-specific evaluation. Generally speaking, a faculty member who says something controversial, even if students don't like it, they get to keep their job, keep teaching classes, but what if no student will ever take their class ever again? And so, it does have these ripple effects. And it is possible for someone to express themselves in a public setting that also calls into question their ability to continue to do their job. I should note, for example, and maybe this is of maybe special interest in this community, that there have been circumstances where medical boards have taken action against physicians because of what they said on social media. And so in 2020, a woman who made anti-Semitic comments on social media then lied when she applied for a residency program at Kern Medical, had her medical certificate revoked by the State Medical Board of Ohio. She wrote on Twitter that she would probably give Jewish people the wrong medicine, for example. Okay. And so that's not the ordinary circumstance, but it does start to get complicated when you see whether or not the expression that in ordinary circumstances would not call into question your ability to engage in your profession creates a circumstance where that becomes an issue. And I think we're all in a position now where lots of professions, whether they're lawyers, physicians, scholars, people in other professions, are trying to work through the implications of that complication.
Yeah, thank you, Howard. We'll just have two more questions for you, and then we'll open it up to the panel. So in recent months, our Office of Prevention and Harassment and Discrimination has received an extraordinarily high number of reports related to the Middle East conflict that highlight the challenges that we've been talking about. That is, challenges of navigating the intersection between the right of free speech and the right to a learning and work environment that's free of harassment and discrimination.
Yeah.
And of course, you mentioned the law and the First Amendment, but Title VI of the Civil Rights Act of 1964 weighs in here as well by saying that no person shall be excluded from participation in, be denied the benefits of, or be subject to discrimination under any program or activity receiving federal financial assistance on the grounds of race, color, national origin, including shared ancestry and ethnic characteristics. Additionally, of course, we have UC policies system-wide that do not tolerate harassment and discrimination or abusive or bullying conduct. And here at UCSF, we hold all of our employees to our pride values that include professionalism and respect.
Yeah.
So we receive federal funding. We receive a lot of federal funding.
Yeah.
So how do we balance the protections of Title VI and the obligations that come with Title VI and the protection of the First Amendment? It seems like it's a tricky balance. And as you know, we all chancellors and presidents across the country received a Dear Colleague letter from the Office of Civil Rights around Title VI obligations here that have been somewhat difficult to navigate. And I know you've been a leader in helping us all think through that. So can you comment on the Title VI First Amendment dilemma?
Sure. This is the central framing of debate about free expression, I think, really since 2015-16, and it continues to get more intense. In the past, it was anti-communism. You have to stop people from saying things that, threaten the national security of the country. That way, there's always an era where there is some kind of speech that people want to suppress for reasons that at the time seem well justified. So, we're caught in the middle, Sam, right? We have obligations under the First Amendment and we have obligations under Title VI. The First Amendment says we cannot sanction or punish people merely because of the expression of a viewpoint, even if that viewpoint is considered hateful or harassing. And so that's the First Amendment. And Title VI says you have to create a non-discriminatory environment. So just 2 or 3 steps to get oriented to it. And it's a complicated debate, and it really does require a lot of additional reflection and debate and discussion. So on the one hand, you could take the view, well, when they say you can't have a discriminatory, harassing environment, what that means is that speech that meets the legal definition of harassment has to be countered, right? And so if someone is harassing someone, in a way in violation of Title VI, that's certainly not protected speech, right? Because that's not merely the expression of a viewpoint, that's harassment. The difficulty comes when the mere expression of certain viewpoints is considered marginalizing or discriminatory. And then that's a very key issue, because one question is, in a university environment, should it ever be the case conceptually that encountering a viewpoint that you think is marginalizing or threatening or discriminatory, that the mere encountering of that viewpoint can in and of itself violate federal law, right? Not that you've been a victim of harassment or threats, but rather you've been exposed to an idea. And it does get to a basic question. Isn't the whole point of a university, in part, to empower people to engage a full range of ideas, learn how to rebut them, right? To empower people rather than silence ideas. But the Office of Civil Rights, especially in the wake of October 7th, has made it very clear to campuses that even if the speech is protected, so it's constitutionally protected speech, if people in encountering that idea believe that they are being marginalized or denied equal access to the educational environment, then even if campuses have no authority to sanction or punish that speech for First Amendment reasons, campuses must nevertheless respond. They cannot be deliberately indifferent. And Sam, as you and I and all of our teams know, ever since these new instructions have come out from the Department of Education in the fall, we don't exactly know precisely what is now required in order to get us not to violate federal law under Title VI. What we do know is you have to take the concerns seriously. We're not under an obligation to censor or punish the people that say things that people don't like. In fact, we're under an obligation not to do that, but to provide support to our community, to provide outreach, to do programming of the sort that was described at the beginning of this event. That is a requirement. And so we can't stop people from being exposed to ideas, but we can take proactive steps to make sure that the exposure of those ideas do not nevertheless deny people an equal opportunity to this environment. But the details of that, Sam, are being clarified every week, every month, as the Office of Civil Rights works through all of these new complaints and circumstances.
Thank you, Howard. I appreciate you bringing at least a modicum of simplicity to an otherwise incredibly complex sort of issue. So my last question for you is, under President Napolitano, when she was leading the UC system, she created under your leadership a National Center for Free Speech and Civic Engagement. Can you just talk a little bit about what that center is, what it does, and what kind of resources are available in the Senate for campuses who are grappling with some of these issues?
Thank you so much, Sam. And folks, if I get to do anything and I get to let you know a little bit about the wonderful work of this center, then I'm going to feel good about the contribution I've made. What we love about this center, under the amazing leadership of its executive director, Michelle Deutschman, who has spent her entire career working on issues of hate speech and hate crimes and circumstances and really trying to provide environments within which everyone can thrive, is that the center is not a finger-wagging advocacy organization of the sort that you get maybe with FIRE and other places, where all it wants to do is tell you that you don't understand things and see if you can just abide by what the center thinks are the right way of thinking about it. What President Napolitano wanted was a center that was was appropriate for a great public research university, which is to say, there are basic principles. And part of the point of the center is to educate people more broadly on what's the difference between free speech, academic freedom, what about speech of staff versus faculty, all of those issues. But they also wanted to set up research, debates, deepen our conversations rather than have people step away from building relationships of mutual understanding. And so the center sponsors a fellows program that identifies people who come in to do very important research projects that could help both the UC community and the broader community of higher ed. It sponsors grants for faculty, students, and staff who want to work on issues and help us all understand them better. Michelle Deutschman runs a podcast called Speech Matters. She's a wonderful host of a podcast where she has a wide range of guests that get into lots of debates, from what we're talking about to what's going on in Texas and Florida, to assaults on DEI, to restrictions on what are happening in libraries. And so there is a very rich terrain here for a great academic center to help us all work through these issues rather than just wag our fingers at each other. And so there's lots of videos, lots of resources. If you just go UC National Center on Free Speech, you'll see a wonderful collection of resources. And I hope all of you find it helpful as we're all thinking through these issues together.
Thank you, Howard, and thank you for this conversation. I know these areas are tricky and difficult, and not everyone is open to thinking about them in a way that these protections are meant for all of us. So I really appreciate the conversation. And I'm now going to turn it back to Lisa to introduce the panel and moderate a Q&A.
Great, thank you so much. So joining us for the panel discussion will be Renee Navarro, Vice Chancellor, as well as Kate Mente, Campus Counsel, and Tracy Tisquay, as well as Errol Lobel. So I'm going to start with some questions that we asked several campus groups to submit prior to the forum, and the first one comes from the Academic Senate. What strategies can we as faculty use to address the tension between the First Amendment right to freedom of expression when abhorrent speech impairs students' ability to receive an education, or employees' ability to work in a non-hostile environment? Kate or Chancellor Gillman?
I'll let Kate go first. The actual pro.
Thank you for that question on that. So strategies for faculty in addressing the tension, of course, is to provide support to those who are impacted by this speech. I think Chancellor Gillman did a really good job of explaining that we are here to expose people to different ideas and how we can constructively engage in those. And I think that that's really important. There are a number of support resources that are listed on the Office of Diversity and Outreach website, which we'll include, I think, in the chat so that people can access those. And I think there's also, we've got a great ombuds office. So if there are issues that can be addressed in that way, engaging with the ombuds office as well to address how to best facilitate those types of discussions.
Great, thank you for that. This one comes from the Staff Assembly. UCSF has a diverse workforce with widely variable social and political views. What is the university's plan to protect its staff, faculty, and learners from intimidation and harassment in the workplace, on campus, for cultural expression or accessories designed to promote inclusion and psychological safety for marginalized communities? And cultural expressions could include articles of clothing or political pins.
So I'll take that one as well, Lisa. I think the first and most important thing is that we have content neutral policies that apply to staff and faculty here. And the protections, of course, also go to our patients as well. So I would add those to the protected parties. We also have very robust policies. If it is in fact harassment or discrimination, these should all be reported immediately to the Office of Prevention of Harassment and Discrimination. And again, we've got resources to support folks within our community who feel an impact from the speech that's at issue. So I would include in that specifically too that we have a dress code policy that applies, and that that it is content neutral, and that we will look at each incident to assess the right steps to take.
Great, thank you so much. And the last one comes from the Graduate and Professional Student Association. How does UCSF ensure that its policies and practices regarding freedom of expression and academic freedom are inclusive and respectful of diverse perspectives, particularly those that may challenge prevailing norms or ideologies?
So I'll take a swing at that one again, and if anyone else wants to jump in. I think the first and most important piece is to make sure that our policies are content neutral, that they are not governing what somebody can say, and that they are consistently enforced and that they are monitored. I also think that we have policies such as our pride values that address professionalism and respect, and that it is also important that when we engage with each other, that we keep those types of values in mind. And that those get addressed in that way as well.
And Lisa, if it's helpful just to put a gloss on that, you know, when you think about why are there norms, customs, and laws to protect people's rights of free expression or academic freedom? Note that you don't need rights of free speech if you're saying things that everybody agrees with. Right. The fundamental structural component of why free speech rights in the long stretch of history are vital for progressive forces and others, and why they are fundamentally, I think, non-conservative in a small c sense, is that they're necessary to allow people to challenge prevailing ways of thinking, right? That, you know, when faculty members in the 19th century were fired from universities because they were teaching Darwin, and the university said that that was inconsistent with the biblical conception of the origins of humankind, you know, they were trying to suppress new ideas and ideas that were challenging the status quo. In the 1910s, the Supreme Court threw people in jail for saying that we shouldn't go into World War I. In the 30s, 40s, and 50s, people were being thrown in jail because they were either communist or communist sympathizers or refused to talk about their background. And so, during the civil rights movement, the South tried to silence people who were challenging Southern apartheid, on the grounds that speech was dangerous speech, it was threatening speech, it was inconsistent with notions of order and decorum. And, broader protections for free speech allowed a lot of voices to be heard. And so, it is, how do our protections of free speech ensure that people can even say things that challenge the existing ways of thinking? The whole point of a free speech regime, and to some extent an academic freedom regime, is to provide that level of protection. But finally, given your other values, it's hard to maintain an academic community if everyone simply thinks that they should just say whatever comes to mind, right? In addition to having a right to saying things, we always have to think about what's the right thing to say in order to maintain a culture of mutual respect, where we can learn from each other, where we can grow with each other as professionals, where we can do the service work we have to do. And that may not always be a matter of constitutional right or not, but it does seem vitally important for all universities to do their work they're going to do, to superimpose on top of a commitment to protecting people's fundamental rights, a notion of establishing norms that allow us to work together and do our best work together.
Thank you so much. And I'll stay with you, Chancellor Gillman, for this question. I'm so appreciative for the work of the UC National Center. Given the intensity of the dialogue about the Middle East war in Gaza, can there be some plan for the center to regularly consult with Arab and Palestinian faculty, staff, and students to understand how to best support this vulnerable population of our community?
Absolutely, and not just that population, but every population that believes the existing framework for how we're thinking about it, what our practices and policies are. We all have to be in this together. And I'll note, by the way, that there is, we've had a number of people from the UCSF community participate in the life of the center in a very important way. There are grants that are called voice grants, where the point of the voice grant is to give $5,000 to members of our community, students, faculty, or staff, who want to work with the center on programs that address very specific issues like the one that is raised in this question. So in addition to having outreach to the center has resources that you might consider that could be very helpful. And in the wake of that, developing programs that might have broader application, would be the whole point of the center in the first place. So I hope you'll learn a little bit more about those programs and participate in them.
Thank you for that. This one's for Tracy, who's the interim director in the Office for the Prevention of Harassment and Discrimination, part of the Office of Diversity and Outreach. Tracy, can you describe the process by which the Office for the Prevention and Harassment and Discrimination assesses complaints of anti-Semitism or anti-Arab sentiment?
Yes, we receive the reports and we need to first make a determination as to whether or not the issue is jurisdictional to our office, meaning that it's an issue that falls under the UC anti-discrimination policy. Sometimes some of the issues are related to the conflict in the Middle East, but there are not some things that fall directly under the policy. And in those instances, we might refer the matter to another office to address. But with the other issues that have come in, and we've received close to 300 reports over the last 4.5 months related to the situation, we have to respond to each one individually and offer an intake meeting with the complainant who has expressed a concern. And then we have to go through an initial assessment process where we looked at, Chancellor Gillman was referring to how we need to really look at each situation on a specific basis. And so depending on the context, the vast majority of the reports that have come into our office, for example, involve social media posts. And so that's where that clash between First Amendment rights and the protections of Title VI come together. And I think across the system, all of our campuses are struggling with how do we assess this, and at what point does something actually meet that threshold of meeting a hostile environment versus this bumps right up to that threshold, but it's still protected speech. And so, as Chancellor Gillman said earlier, under those circumstances, if it's not something that we can move forward to a formal investigation in our office, we do have an obligation to put mitigating measures into place, make sure that a complainant has access to support resources, and that we connect to the larger efforts going on across the campus. Dr. Navarro's office overall with ODO has been engaged in programming activities, and so we really need to make sure that we look at the situation from a big picture perspective as well as the individual complainant situation.
Thank you for that. Can you give us a little bit of insight into those 300 reports? Are they primarily internal or external?
That's a great question. I don't have the current breakdown of the numbers, but we have received a good proportion of reports that have come from outside of the university, from non-affiliates, but obviously the vast majority are from students, staff, faculty, and also from patients. And so, we treat those all equally under the anti-discrimination policy.
Thank you. This one's for Tracy or Renee. If UCSF is assessing complaints of anti-Semitism and Islamophobia, why don't we hear about them?
We have to maintain the privacy of folks who come forward to our office. We often hear from complainants that they're actually afraid to reveal their identities. We have many anonymous complaints that come into our office, which makes it a little bit more difficult for us to be able to directly respond if we don't have the details. But people have expressed deep concerns about retaliation if they were to come forward with a report and their names are involved. And so we need to make sure that we protect them. The policy explicitly prohibits retaliation against somebody who has engaged in any kind of complaint process in our office. So we don't share that information about specifics, but we can share information about the sort of aggregate number of reports and types of reports that we're receiving, which we have done in different forms, but not perhaps on a campus-wide level.
And I'll just add that the Office for the Prevention of Harassment and Discrimination is a neutral fact-finding body responsible for investigating the facts around a complaint as it relates to the policy. If in fact there's evidence that there's violation of policy, those matters are then turned over to a different party for the adjudication and potential for sanctioning. Be it faculty, it goes to academic affairs, be it a staff, would be labor employee relations, and for students, it would go to student conduct. So, and there become issues that are obviously governed by privacy, concerns and restraints.
Thank you. This one's for Errol Lobo, who's Vice Chair of the Academic Senate. So how has the Academic Senate been dealing with this particular issue and the academic freedom issue?
In the 30 seconds that I have, I will say in December's meeting, we had a meeting with a group of people who came forward and had a concern about the anti-Semitism. And it was a very detailed meeting, it was a very intense meeting. And so in the following meeting, we invited a gentleman who's a psychiatrist here who basically is of Arab descent, of Palestinian descent. And so we wanted to get both sides, and we're basically trying to put a letter together for the professors, for the people in the Academic Senate, as somewhat of what we found and how we can move forward as one. I think I would defer to Chancellor Gillman about the academic freedom issues, because he went into that very in detail.
And look, Errol, listen, it's vitally important that none of this, the academic freedom fundamentally really does require the faculty to kind of engage in an ongoing way on these issues. That is what the University of California policy requires. And I'll just say that the UC National Center did a system-wide webinar a couple of days ago with me and the system-wide chair of the Academic Senate and Michelle Deutschman. Academic Freedom 101, if you wanted to go into a little more detail, that'll be up on the website. And so if you want to take an additional step in that direction to increase your engagement and to set us up for better conversations down the road, I invite you to check out that webinar.
Thank you.
Great. This one is for you, Chancellor Gillman. Does freedom of speech apply to institutions? If so, is there any difference from how it applies to individuals?
It's a very important question. So free speech, the centerpiece of free speech under the First Amendment is that individual persons have a right to express themselves without getting in trouble by the government. Okay, so that's kind of the anchoring position. But institutions also have the right to speak. But it raises very interesting questions about, are those rights the same rights that individuals have? Now, when you're talking about a media company like the New York Times, the assumption is that the owners and editors of the New York Times, while technically a legal corporation, have First Amendment rights. And you might know the Supreme Court has made some decisions about how First Amendment rights of corporations also mean that you can't limit the kinds of donations that corporations can make to our political system. And not everyone agrees with that sensibility, but the corporate entity in a non-university environment is recognized as having free speech rights, First Amendment rights. Institutions have a right to speak. Within the University of California, for example, the regents of the University of California are completely free on behalf of the institution to speak on behalf of the institution. Same with the president, and in limited circumstances, the chancellors. The Academic Senate has the authority as a body to take positions on a variety of issues. Staff Assembly as a body has the right to take positions on issues. And in those circumstances, though, you really have to decide what kind of speech is speech that is consistent with the overall mission of the institution. We all know that there are circumstances where people expect leaders of an institution to speak. But we also have an obligation to speak in ways that give everyone a voice. And for me to do a running commentary on every opinion someone expresses on the campus is also not consistent with me trying to ensure a broad range of opinions. It's a very difficult balancing act and no one thinks that everyone gets it right. I will say I've tried to explain it to my community because I have on my website a statement on statements, where I have a statement about when I make statements and when I don't make statements. It's not going to make everyone happy, but it does, I think, convey a little bit of the difficulty of when people want to speak on behalf of the institution and not. Mostly, though, the point of the institution is to give you voice and to ensure that your voices can be protected and recognized, and that you're empowered to engage a full range of ideas, I think.
Thank you so much. And with that, we are at the end of our program. I want to thank all of the speakers and participants, and that announced that this forum will be available for viewing post the event. So thank you again for joining us, and I wish you a great afternoon. Thank you so much.